News Radio WJPF. I want to thank my guest, Summer Vanderbilt. Was able to make it here. She was worried she wasn't going to be able to, but she comes squealing around the corner on two tires on one side of the car, so you did good.
You never know with all those stoplights in Marion what you're going to get.
Every day's a surprise. Reason Summer joined us today, and we want to encourage you, if you've got questions about the Paid Leave for Everyone Act, to text now 618-985-5803. The Paid Leave for All Workers Act, or Paid Leave for All Act, begins January 1st. Before we get started, for people who may be unfamiliar, this is Summer's second visit, what's the basic math? For a part-time worker or full-time worker, depending on circumstances, you work X number of hours for X number of time off. What's the math?
Yeah, so when we break it down, doesn't matter full-time, part-time, temporary, contract, anything, they are going to need to keep track of how many hours that person's working. Once they hit 40 hours, they're going to accrue 1 hour.
40 for one. Mm-hmm. Our first question from Mike. The 40 hours paid time off is in addition to any paid holidays. Is that correct?
Yes, paid holidays are not included in this. So, of course, now if you do have employees that aren't qualified for paid holidays, Maybe, that's something to consider. Are you giving them paid holidays? Are they not? Is it part of their work schedule? When you're looking at some of the rules from this, one of the things it says is that paid leave, it has to be used on your normal work day. So if you don't do paid holidays for your employees, if you're, at a restaurant and you guys are closed on Christmas and nobody's paid because that's not a normal working day, you don't have to do the paid holidays. It does not say anything about paid holidays in these rules.
All right. Now, is there a limit to how much time someone can accrue?
That's up to the employer. So the minimum is 40 hours that they are able to accrue. So if you want to let them accrue 60 hours, if you can make that accrual plan however you want. But the state is telling us that the minimum is 1 hour for every 40 hours worked. Now we know if we have a part-time employee that doesn't work enough hours throughout the year, they may not hit that full 40 hours. But that is the rate that the state has put in place.
But you will have X number of portion of an hours built up,
mm-hmm.
right?
Yeah, they could maybe, some of the math I've seen with different examples say, based on the amount of time that they're working, maybe this person is only going to accrue, say, 26 hours over the course of the year. It's just based on how much they're working. So if they're not working that full amount, they're not going to get the full potential there.
All right. Now, I've got my friend George, who's been a business owner since I met him in Harrisburg over 40 years ago. And he's listening this morning. He says, how do you track the accrued time? This is something you and I talked about before. The crucial nature and implications that come from all of the tracking. Do you want to try to tackle that with me?
Yes. This is this is why we really have been diving in and looking at this law and what it means for employers. A part of our business is payroll and timekeeping and keeping employers compliant. That's a big piece when you're looking at these rules that the state is really stressing. You have to keep track of the hours your employees are working. How many hours did they work on Monday? How many did they work on Tuesday? And you need to know that. And then you need to know how much time they're accruing by the end of the week. Did they work 37 hours? Did they not accrue anything? Are they going to accrue the following week? And at what point are they going to hit that accrual? What you're going to need is a timekeeping system and a system that's going to track the accruals for you. That's going to take a lot of the headache out of it. You can build out an accrual plan that will know, okay, 40 hours has been hit, 1 hour.
Okay.
Or however you want to put that accrual.
All right. Now, there are other implications to this, and this comes from some notes that Summer and I have been talking about. The importance of record keeping. Unused time does not have to be paid out upon separation. But if they come back, which happens, you have to still know what happened.
There's a little bit of, it depends on which route you take, right? If you are front-loading those hours, you say January 1, every year on January 1, I am going to front-load these hours to my employees. they can take it whenever they want. Then if they leave, say July 1st, you have to pay the rest of those hours out that they did not use.
Okay. Go ahead.
But if you're doing an accrual basis, right? If every week, once they hit the 40, you're adding an hour to it, you do not have to pay that. It depends on how you separate it, really. If you're adding it to your current PTO plan, this is where your policy is going to have to come in place.
Okay. Let's tell people, because you used a term that I thought was important, that I see that is kind of depending on how you feel about money and CPAs and time and hours and expenses. You just used the term front load 40 hours. If you do that, you're hired. Now, I don't think they're not allowed to use it for X number of weeks or months once they start working.
You have a 90-day grace period.
First 90 days, you don't have to let them use any time that's accrued or front loaded.
Correct.
Okay. But if you say, look, you work for us, we're going to give you 40 hours right now, but you can't use it for X number of days. This technique seems to cover a lot of ground when it comes to hassles. Am I wrong here by front loading?
It depends on how you feel about it. So I've talked to a lot of companies that have had employees a really long time. They have a staff that they are very comfortable with, and front loading it to them is no problem. You have others that see a lot of turnover, and they're hiring new employees all the time. And to them, knowing if they front load it and not sure if this employee is going to be around in 6 months and being responsible for paying out the rest of that leave that maybe this person didn't use, that's a financial burden on them that they don't want to deal with.
Right, and I understand why. Let's take a few more questions from our listeners on the American Mama text line from Andy. Does this affect student employees that are employed by either a high school or college or a high school co-op employee? Good question, huh?
That is a good question. There are rules in here that talk about school districts.
And carve-outs for school districts? Mm-hmm. Okay.
That's a question that I have not dove in and looked at, so I'm not going to give a good answer there.
Okay, here's another one from Nick. Is this use it or lose it? That's got more than one answer.
Once again, it just depends on your company's PTO policy, what they decide to put into place, and it can be or it can't be. So if you front load it, yes, then it would be a use it or lose it. If you do an accrue, it's going to roll over into the next year.
If you have accrued time and you leave that job, they do not have to pay you that accrued time.
As long as it is in its own bucket.
If it's front-loaded, yes.
If you lump it in with your company's existing paid leave policy, if you don't separate it out and say this is the Illinois Paid Leave for All Workers Act, there's a little caveat there. It has to be in its own bucket.
All right. So when somebody wants time off, they don't have to supply a reason why they want it.
No reason.
But you can put a limit on how much time you can take at a time.
You can, yes. So we really have you can say like you have to take a minimum of 2 hours. You can't just say, I'm going to take a half hour here because I want to leave work early for the day.
All right. Now, my understanding, Summer, is that is in the law itself. That's not policy. 2 hours is you can do that by the law.
You need to write that into your policy.
Okay. All right. That's a good one. Okay. All right. So, notice. How much time does that employee have to give you in warning that they're going to take that time off?
So it does say that if the leave is a foreseeable absence, you can have in your policy requesting a 7-day notice to use the leave. However, if the leave isn't foreseeable, you can't just say, sorry, you can't take it. So with this law, they don't have to provide you any documentation on why they're taking leave. They don't have to tell you why. So that's where it comes in. What's considered foreseeable and what's considered non-foreseeable in this. That's the language they use, but not being able to ask what the reason is for or providing any documentation, you can't really justify if this was a foreseeable or non-foreseeable absence.
Here's a question from the American Monument text line. Does this cover federal and state government employees who work in the state of Illinois? Isn't it interesting? Our listeners always come up with the best questions.
They do. They definitely do. I believe the state has their own rules in this already. But don't quote me on that. I don't deal with state employees. So whenever I'm reading all of this, I work with private companies. So I realize the state will do what they want.
We'll have to figure it out then later.
We will.
Later.
We'll figure it out for the next time.
All right. So this is something else that you had talked about. We brushed against this earlier. You really have a lot of different responsibilities when it comes to if that employee wants to know how much time they have, you've got to know. But there's some issues here when it comes to this. Employers are required to provide updated accrual balances to the employee upon request.
That's where you're going to want to have a solid timekeeping system that can track your accrual plan. Right. Whenever they log in or view their electronic timekeeping, it should be able to show them their accrual balance, how much they've used, when they've used it.
Okay. Now those last two are particularly important. I'm kind of this person. If it's off the books, it's off the books, and I don't have to worry about that anymore. I do by default know when people took that that time off. I get that. But, you have to be able to, say, okay, you've built up this much time, you took this much time, and you took it on this date, and you need to keep that in your records for
3 years. Now, what we're going to see, and a big piece of this that I think a lot of employers, they maybe have the mindset, okay, I'm not going to comply with this. This is something that's just going to cost me more money, more time, more headache. I'm just going to pay the fine and be done with it, right? We saw a lot of this when the ACA came out. Still, a lot of employers are just paying the fine and not dealing with offering that. In this sense, the fine, $2,500, plus the employee that goes in and makes that complaint, you're going to have to pay them for the hours that they should have been accruing. And then, of course, when the Department of Labor gets involved, they're going to look at, well, who else wasn't offered PTO? How much do you owe them as well? And they're going to go back into your record keeping to see what's there.
Now, here's a question, and I think it's important, and semantics is important in this law. Here's a question from the American Monument text line from Terry. So can vacation be retitled to paid time off? This is something you and I talked about last time, that maybe it's time we start using some different verbiage because it's more accurate, relevant legally to this law, PTO.
Yes, that's why we're telling everybody, take your policy out, look at these rules, and figure out what makes sense and what doesn't, and where you need to make adjustments. It's okay to adjust the policy you have in place. It's okay to make changes to that and have your employee in mind. Think about them and what's really going to make sense.
It's interesting. I was looking at information from summer, and we talked about this. Employees will start to accrue hours from the start of employment, but will not be eligible to use the hours until 90 days. We talked about that. So that'll be March 31st of 2024. People will begin and it will start, or whichever date is later. So you've got 90 days in. You've got to have your record keeping. Any accrued but unused time will be carried over into the next calendar year unless the time was front-loaded. Now, if you give them the 40 hours, you can say it's an annual event. You have to be done by December 31st.
Yes.
Right?
Yeah.
All right. Here's another one from the American Monument text line. If you offer PTO already, that means the state requirements are required to provide an additional 40 hours of PTO?
No, you just need to look at your plan and make sure that the leave that you're offering is not restricted. And maybe you have it in there that they need to use 4 hours at a time. You make a few adjustments just to make sure that you're compliant with what the state has put out in these rules.
All right. So what's the question? What's the thing that you want people to know from your experience that you think this is significant and you've got the spotlight in your hand right now, Summer Vanderbilt of Higher Level. I want to put the spotlight on this. Do not forget this. What would the spotlight go on to?
I don't know that it's the spotlight. I think the fines are a really big one, because when employees start hearing about this and thinking, I wasn't offered the time off, this wasn't something that I was offered, they can go back 3 years. They may have gone on and worked somewhere else, and they're long out of your memory, right? But maybe down the road they hear about this Paid Leave Act. And, oh, I should have been earning time off when I worked at this place, and I didn't get it. It's so easy for them to go online and file a complaint.
All right. But that's not retroactive. It starts January 1st. They can't
Correct.
say January 1st, you didn't give me time off last year and I want it now.
Right.
It's not retroactive. So it starts the 1st of this year of 24 and then moves forward.
Mm-hmm.
Okay. Well, it looks like we've got almost all of our questions, even some of the redundant ones. We got some of the same stuff, use it or lose it in particular, and who employees that are eligible and federal and state employees. But I think we've kind of covered this pretty well. Somebody created a Paid Leave for All software package yet?
So with our software that we have, you can build a customized plan based on your policy and what you want it to say. So it's really, you're going to be able to carve out a policy. Illinois Paid Leave for All workers. This is that plan. And then here's my regular PTO plan, vacation, sick leave, all of that. And you can really, it's not a one-size-fits-all. It's different for every company, and we know that. All right.
That was a question that was asked to me last night, and I was talking to a friend who runs a business. He says, is there a minimum number of part-time employees that you have to have before this law goes into effect?
No, you can have one employee, and you're still going to have to add the PTO.
All right. Now, here's one that I expected earlier from Dennis that you and I brushed against too in the first interview, and I think this is very important. Dennis says, if you only have 4 employees and they all want to take the same day off, what does the employer do?
Okay, so you can decline use of those hours based on hardship of the company, right? So if it would significantly impact your business operations based on your employer size, you can tell them, sorry, you can't use this leave. However, this goes back to your record keeping and your documentation. You have to have documentation that you declined that request, and it needs to be like in writing. You can't just tell them when they call you up and say, hey, I'm calling in for the day. You need to have an email or however you communicate with those employees saying, sorry, you cannot take your time because Bob and Sally have already requested the day off and we need to continue operations.
Is this the case where you need to clear this up in policy about what hardship on the business is from the day one situation here, right?
Yes. You need to have that in your policy.
Because if Bob, Sally, Tom, and Jesse all want off, you need to have told them they can't do that before they ask.
Correct. You need to have it in that policy on what would determine a hardship. Now, when you are doing that, you're declining that request, you do have to make sure that the employee has an opportunity to use their paid leave that they're entitled to within the 12 months. So have in mind, if they want to use it, in a few weeks on a certain day, you need to just make sure that they have the time throughout the rest of the year that they're going to be able to use it.
Summer Vanderbilt, Higher Level. You've been immeasurable help. A lot of people. So thank you for your time. Really appreciating the time and effort you put into this and the rush to be able to get here and join us on time and take care of your life too. I appreciate the extra effort, and I know everybody who's listening does too, so thank you.
Of course.
Summer Vanderbilt, News Radio, WJPF.